In this case, the court did not bless a search and arrest of an individual who admitted to smoking marijuana some hours prior to being pulled over, where the officers failed to conduct any field sobriety tests to determine whether the drug use had any actual effect on this person's ability to drive. Here, in this case, we're also going to look at the fact that when the officer even slightly moves the door on the vehicle, that can be deemed an unlawful search under the Fourth Amendment. And before we go on, I want to thank you for watching me here on YouTube. Welcome to the Law Stash channel. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lawstash.com and check out some of the merch, including these Do Not Arrest This Person t-shirts. And if you're listening to this video or the podcast at the end of 2024 here in December, if you go to lawstash.com now and put in the promo code SANTA2024, you will get 10% off all merchandise. Thanks for watching. Thanks for supporting this channel, subscribing. Let's go on with the video.
Quick message from Law Stash. Are you charged with a crime? Or do you want to know your rights if stopped by police? Watch California attorney Anton Vieltsin discuss legal cases from the Supreme Court, Ninth Circuit, and California state courts on the Law Stash YouTube page. Anton has handled hundreds of federal and state criminal cases, has an in-depth knowledge of the law, and has the best mustache ever. Subscribe to the Law Stash YouTube page. That's LAWSTACHE.
Today we're discussing United States v. Russell, a case from the Western District of Washington. First, let me give you some factual background. We're in Seattle, Washington, around 1:20 in the morning. Officers are responding to a 911 call. They're driving on Aurora Avenue. Unrelated to the call, they see a white Volvo parked in the middle of the road. They respond to the 911 call. About 10 minutes later, they're driving back on Aurora Avenue and they see the white Volvo almost in the same position. Of course, we don't know whether that vehicle left and came back, but the officers thought that was suspicious. So they pull behind the Volvo. As they get behind the Volvo, it takes off, but it's not driving erratically. It's not making any illegal moves. It is driving exactly the speed limit, so everything is fine. But the officers observe that the vehicle does not have a license plate, so they make a decision to pull over this vehicle. The vehicle moves to the left and stops in the left lane, blocking some traffic. When the officers approach, Mr. Russell provides his identification. He gives the license, the registration, insurance for the vehicle. The officers, when they approach the vehicle, right away smelled some marijuana. They began to talk to Mr. Russell about the reason for the stop. They explain to him that it is because he doesn't have a license plate. He explains that it is his vehicle, but he's still waiting for the license plate to arrive from the dealer. He does, however, have a temporary tag behind the rear window, and he points it out to the officers. Now, the officers at first couldn't see the temporary tag because the rear window was very tinted. Now that he explained this, the officers continued on with giving him the ticket for not having the license plate at first, or at least they're trying to investigate further. During their investigation, whether the license and registration and all the documents are in order, they realize that Mr. Russell does have some prior felony convictions. When the officers come back to the vehicle, they go back and forth talking about the fact that Mr. Russell parked on the left lane blocking traffic and how this was somewhat dangerous during a traffic stop. Now, Mr. Russell explained that the reason he parked on the left was because there was no shoulder on the right side, and his plan initially was to make a turn to a side street on the left. But he eventually got stopped and obviously pulled over where he did. The officers then asked him whether he had anything to drink, and he said no. They asked him whether he had any firearms in the vehicle, and he said no. They then asked him whether he smoked any marijuana, and he admitted that he smoked one blunt about 2 hours prior to driving. But he said that it had no effect on him. And if you look at the body cam footage that the court observed, the court noted that Mr. Russell exited the vehicle when asked Without any hesitation, his speech was not slurred, and he appeared to be sober. Nevertheless, the officers then asked Mr. Russell to move over out of the vehicle towards the sidewalk so they can conduct a field sobriety test. Now, Mr. Russell said that he's willing to do the field sobriety test, but first he wanted to lock his vehicle. At this point, the officers also noted that when they came back to the vehicle initially to give back the documents to Mr. Russell, one of the officers slightly opened the door a little bit further out, and he could see a firearm on the ground under the seat sticking out, just a pistol. Now, because Mr. Russell wanted to lock the doors and didn't initially walk to the sidewalk right away, the officers then said, "Forget about it. We're just arresting you for the DUI." Now, Mr. Russell argues that the search, the opening the door, and the firearm, and the arrest for the DUI are illegal in violation of the Fourth Amendment. He says that the search is illegal because the officers were not permitted to open the door, and that the arrest for the DUI is not supported by probable cause. Now, of course, what he's trying to suppress here is the firearm that is found inside the vehicle. Because at the end of the day, Mr. Russell is actually charged with being a felon in possession of a firearm. So when we're talking about the Fourth Amendment, first we're going to go step by step, just like the court does. And the first thing we do is see whether there was a basis for the stop initially. The Fourth Amendment permits an officer to initiate a brief investigative traffic stop when he has a particularized and objective basis for suspecting the particular person stopped of criminal activity. In other words, there has to be reasonable suspicion that criminal activity is afoot. And here the court says there was reasonable suspicion because Mr. Russell failed to visibly display a license plate, which is an infraction in Seattle, Washington. And even though he had a temporary tag, even that was invisible because of the dark tint on his rear window. So the initial stop is legal under the Fourth Amendment. The next thing we're going to talk about is the duration of the stop. Mr. Russell argues that the stop should have ended when the officers observed the temporary tag under the window, and as soon as they saw it, they should have let him go. Like a Terry stop, the tolerable duration of police inquiries in the traffic stop context is determined by the seizure's mission to address the traffic violation that warranted the stop and attend the related safety concerns. Authority for the seizure thus ends when the tasks tied to the traffic infraction are, or reasonably should have been, completed. An investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. The court says that the officers are allowed to prolong the stop if they develop reasonable suspicion or probable cause that another crime is occurring. And here, the officers had suspicion that Mr. Russell was under the influence of marijuana, a potential DUI. And so the court says the initial stop is legal, and so is the duration of the stop. Officers were permitted to investigate a potential DUI. Now let's move on to the third item that Mr. Russell brings. He says that the search of his vehicle was unlawful in violation of his Fourth Amendment rights. Now remember, warrantless searches are per se unreasonable under the Fourth Amendment, and the government has to rely on some exception to the warrant requirement if they try to bring the evidence that they seized during the stop to trial. Now here the government will try to rely on what's called a plain view doctrine. If you're unfamiliar with this doctrine, I suggest that after you watch this video, go on my channel and search for vehicular searches without a warrant. This is a series of videos I've made a few years ago where I discussed every single exception that relates to traffic stops, vehicular searches. One of those videos talks about plain view doctrine. And by the way, in the whole series, I don't focus on just one case. I give you summaries of all the different cases that relate to a particular exception. Now here we're talking about the plain view doctrine. If the officers see some item that's incriminating by its nature, they can of course seize that item. But here's the thing. The officers have to be seeing the item from a lawful vantage point. And here the court says, when the officer came back to the vehicle, the door was slightly open, but he pushed it a little bit further out. That act of pushing the door further out was unlawful because it was done without consent and without a warrant. This was a search under the Fourth Amendment. And as soon as he's done it, only then he was able to see the firearm under the seat. And so the court says this is unlawful under the Fourth Amendment. And the item that was seized, the firearm, cannot be used against Mr. Russell in trial. And so the whole case sort of falls apart for the government. Now, we can stop here, but the court moves on and talks about the fourth item here for Mr. Russell. Mr. Russell argues that the officers did not possess probable cause to arrest him for the marijuana DUI at the time of his arrest. Probable cause is established when, under the totality of circumstances known to the arresting officers, a prudent person would have concluded that there was a fair probability that the suspect had committed a crime. To determine whether an officer had probable cause for an arrest, we examine the events leading up to the arrest and then decide whether these historical events, viewed from the standpoint of an objective, reasonable police officer, amount to probable cause. The government tries to throw a bunch of factors to justify a DUI arrest, including the fact that Mr. Russell was parked in the middle of the roadway on Aurora Avenue at 1:20 in the morning, and that he later was pulled over on the left side of the road. Well, the court says these factors are not showing impairment. Even a sober driver could be parked in the middle of the roadway. And the fact that Mr. Russell parked on the left side when he was eventually pulled over, well, Mr. Russell explained it. He said there was no shoulder on the right side and that he initially wanted to make a left turn into a side street, but he got pulled over on the left side and he eventually just stopped there. Both of these factors do not show impairment. The only thing that we have here that might show that Mr. Russell is under the influence of marijuana, which impaired his driving abilities, is the fact that the officers testified that Mr. Russell had bloodshot and glassy eyes. And the second factor, that he admitted that he smoked marijuana about 2 hours prior to being pulled over. Well, the court says the officers were justified in investigating a DUI further. They could have conducted field sobriety tests. But if they didn't, the court says these two factors alone are not enough to show probable cause that somebody is under impairment and driving under the influence of marijuana. They should have either investigated further, for example, conducting field sobriety tests, or they should have let Mr. Russell go. I hope you've learned something today. It was an interesting case where we talked about the justification for the initial stop, the prolonged stop, probable cause to arrest an individual, particularly for a DUI, and maybe the most interesting thing, that even a slight movement of the door by the officer could be deemed an unlawful search under the Fourth Amendment. I hope you enjoyed this video, and if you did, give it a thumbs up. If you're new to the Lost Ash channel, hit that subscribe button. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to lostash.com and check out some of the merch, including the Do Not Arrest This Person t-shirts. Thanks for watching. Happy holidays.